I'm here to introduce Jay Fullman to you today. Jay is did his undergraduate work at Pepperdine University and graduated with summa cum laude honors. He got his Juris Doctorate from USC. UCLA fans don't hold that against him. He's still a very good guy. Jay has been an attorney and counselor at law for over 39 years in the area here. From our experience, more importantly, he's been participating at OLLI and giving talks to OLLI for at least 10 years that I know of, because I joined about a little over 10 years ago, and Jay was participating with, I think it was either the TIR sessions, the early TIR sessions, or Jim Kashiwada's and Danielle Blunt's personal finance. So he has done both of those classes over the years, and we really appreciate that support. Jay is more than just an estate planning attorney. He works with individuals and small businesses to protect their assets and help them plan for the future. He helps individuals, married couples, and small businesses to find solutions to any legal issues that arise. That's from estate planning, but also corporations, contracts and leases, and other services that he provides to individuals. Jay has been married to Janice for 43 years. Congratulations. In Southern California, that's amazing as it is. Jay and Janice live in Brea. They have 3 children and 3 grandsons. Jay is active outside. How he finds time, I'm not sure. He's actively involved with the Yorba Church of Christ as an elder. He's a chairman and board of directors of the Orange County Christian School, located in Anaheim. He volunteers for an arbiter for the Orange County Bar Association, and he teaches classes here, which we really appreciate. He also bicycles, is a photographer, enjoys NASCAR auto racing, and is a Civil War history buff. So broad range of interests. We certainly enjoy having you here with us today, Jay. So Jay, why don't you take it away?
Okay. It's good to be here. Thank you. So the topic here is essentially how to avoid probate, and trust being the primary vehicle through which that is done. There are some other alternatives we're going to take a look at besides trust, but the main thrust and focus will be how to avoid probate by using trusts. And we'll get into the details of what exactly what that means. But before we can really get into an understanding of why use a trust or why use other mechanisms to avoid probate, we've got to understand what probate is and why people frequently want to avoid probate. There are a number of factors which go into whether a probate may be required. One of the factors is whether there's a will but no trust, or no will and no trust. So essentially no real planning has been done. In either of those circumstances, a probate might be required, and the monetary threshold for when a probate is required is gross value of assets of over $150,000, or real property having a gross value of more than $50,000. So the cash or value threshold for what would otherwise need to go through a probate is fairly low compared to what a lot of people have accumulated over time in their lives. And you can also have a situation where if even if there is a trust, probate might be required if that trust is not properly funded. So we're going to go through and talk about the funding process because in my years of practice, I've seen a number of situations where there were, in my opinion, unnecessary expenses required in order to get assets transferred to a trust for planning and distribution purposes, which those expenses would not have been required if the trust that was established was properly funded. One of the one of the other things to keep in mind with respect to probate is if there is no will, there obviously, or maybe it's not obvious, but if there's no will, there are no beneficiaries designated. And if there are no beneficiaries designated, the state has basically an estate plan already established. So under state law, if there is no will, no trust, no real planning has been done, then the assets would go to the natural heirs of the person who is deceased, the person who passes away. And typically that would be their children, or if there are no children, there would be others. But the will allows somebody to designate beneficiaries. But like I said before, if there is no trust, the will still may need to be probated. The term probate comes from a Latin word meaning to prove. And so the idea being that if there is a will, that it needs to be proved in court so that the assets can go to the beneficiaries designated in that will. Or like I said just a minute ago, if there is no will, then the assets go to the legal heirs under California law. And as I sometimes tell people, you know, if you don't have a plan in place, the state of California has a plan for you. You just may not like the plan. So that's why I try to encourage people to do planning. And hopefully you'll get some good planning ideas out of this time together this morning. One of the advantages that can be derived from probate is just the simple matter of probate court supervision. If there's a question or a concern regarding family infighting, there could be situations where having a probate court supervision might be preferred to having a trust administration, which is private and not usually court supervised. Another advantage for probate is to make sure that the deceased's heirs are protected. And as I indicated, who's an heir may not necessarily coincide with who's a beneficiary if somebody wants to designate beneficiaries. But if the interest is making sure that specifically children or other legal heirs are protected, then probate could be desirable. Other things that we might not necessarily consider advantages is the protection of creditors. In a probate, there is a very specific mechanism involving an initial publication of the probate petition, and that gives notice to creditors, and also a specific written notice to known creditors, so that if they have some type of a claim against the estate of the deceased, then they can those creditors can submit a claim in order to make sure that they get paid. There are also some procedures available under law relating to trusts, but they're not quite as well, A, time consuming, and B, as definitive as the procedures for protecting creditors in a probate. And of course, we always want to make sure that our federal and state taxing authorities are protected. So in order to make sure that they're protected, a probate can be desirable. Tongue in cheek, okay. Some disadvantages of probate. Primarily it relates to fees and expenses. I've had a number of people indicate that they don't want the state to receive the assets. They don't want the state of California to basically be waiting at the door when somebody passes away so that the state can receive a benefit from the estate of the deceased. That rarely occurs. Other than tax payments that may be due, the state, California, does not receive anything when a probate estate is being administered, other than some court fees. I mean, those go to the court, but those court fees are minimal compared to the work involved for the court in terms of a probate. I mean, the initial court filing fee is less than $500. There's also a petition fee at the end that's also less than $500. So if the court's getting $1,000 for administering a probate, that's hardly a worthwhile payment of fees. From a practical standpoint, the state does not receive much of anything through a probate other than the satisfaction from a public policy standpoint that making sure that everybody's protected by a court supervised process. But other than court fees, the things that have to be recognized or taken into consideration for a probate are the attorney's fees and the executor, the executor of the will, or administrator if it's a probate involving no will. Those fees come out of the estate. There's also probate bond fees typically required. One thing that the probate laws do is establish what would ordinarily be referred to as a performance bond to make sure that the executor or administrator properly performs their function. And if they don't, essentially if they walk off with estate money, then the performance bond or the probate bond is there to provide the beneficiaries or the heirs with a source of money that can be to compensate them for any loss through the probate. Probate bonds are almost never resorted to because it's court supervised, and usually there are attorneys administering the estate. The probability or actual occurrence of administrators or executors walking off with the estate money is extremely small. Essentially, in a probate, you've got an unnecessary probate bond required, and probate bonds vary based upon the value of the estate, just like the attorney's fees and administrator or executor fees do, but they're typically set as a percentage of the assets, the gross value of the assets in the estate. So frequently your bond fees, your executor fees, attorney's fees are going to be much higher in a probate than they would be in a trust administration. There's also probate referee fees and a few other things. The probate, as part of the process for probate, all the assets of the estate have to be valued, and that's done by an appraiser who is actually called a probate referee. If it would make more sense, and if I were writing the laws, I would call them probate appraisers, but they're called probate referees. So you've got these expenses that need to be considered, which can be a disadvantage as far as a lot of people are concerned. Other disadvantages are delays in distribution and lack of availability of the assets to the heirs and beneficiaries. A probate process typically is much longer than a trust administration process, especially now when with COVID-19, the courts were essentially closed for all practical purposes for over 2 months. And things were already being delayed as far as probate administration in Orange County, and the courts having been closed for 2 months have just put the delays, made the delays worse. Even before COVID-19 occurred, I had a probate where we filed a petition to distribute or get court approval to distribute the assets. We filed that in December of 2019, a hearing date in July. And then unfortunately, because that was in the midst of the Corona-19 shutdown as far as the courts were concerned, that hearing then got put off to January of 2021. So basically, in that particular probate, over a year from the date we were ready to distribute assets, we need to wait a year or more than a year for court approval in order to get those assets distributed. There is some concern in probates about assets being wasted, and this really derives from the fact that there's a lot of due process requirements in probate, and generally due process is good, but due process can also be expensive. So sometimes the delays or just administration in a probate can result in a decrease in value of assets, and can easily force or result in the forced sale of assets. You don't have as much control in a probate regarding whether assets are going to be sold or when assets are going to be sold. You cannot wait for an improved market condition, for example. Usually if there are assets that need to be sold, they need to be sold promptly without delay. So, that could have an effect on what the ultimate value of the assets are as far as what gets distributed to the heirs of the beneficiaries. There's also the inconvenience of dealing with the court and bureaucratic rules. Again, the due process requirements can result in a lot of what would appear to most people to be unnecessary restrictions and activities that need to be accomplished, which contribute to the expense of probate. Another thing that some people don't like is the fact that probate proceedings are open to the public. Whatever court filings are made that identify assets, the executor or the administrator are, including providing their address and phone number. So they have a tendency sometimes to be contacted by real estate agents or other people who are using access to the court records to try to generate business for themselves. So just having the probate proceedings being public can be a disadvantage. So getting into trusts, and not about all trusts. The focus here is trusts primarily for estate planning purposes. We're not going to cover all possible trusts. There are quite a variety of trusts. Typically, each individual trust prepared for each person or married couple is going to be unique to that person or that couple, but there's really quite a few categories, I guess, of trusts that are out there for different things. What we're going to be talking about are trusts that are used by families to transfer assets typically from one generation to the next, or designate charitable beneficiaries to a person's estate. And these types of trusts are often referred to as revocable or living, or sometimes revocable living trusts. An older term, because it comes from the Latin inter vivos, is still used some, but not as often. And inter vivos just meaning during lifetime or during life. So this is a trust that's in effect during life, and is used to basically as a transition document to distribute assets from the owner after they become deceased. So that's been the primary focus and purpose of trusts has been to avoid probate. There's also some other advantages we'll talk about as time goes along. When trusts were first came into use, they were originally for managing very large estates. Wealthy people had the time and energy to have attorneys working on ways to help them control where assets were going to be distributed. And over time, trusts have become more and more popular and not nearly as expensive as they would have been initially. Typically now, having a trust and trust administration is much cheaper than having either a will or no will with a probate. So, and so the kind of the way to think about trusts, one concept is to consider trusts a contract. which protects and distributes assets. It's essentially, typically, a contract between you and yourself, and we'll get into the explanation for that in a minute. But so it's essentially a contract with yourself established under state law, and you designate where assets get distributed. Another way to think about the trust that we use in estate planning is it's like having a family-owned company. You put assets into the company or into the trust. You're typically the president and owner of that company as president, so you make the decisions regarding how that company assets are going to be managed and direct where those company assets go. If the trust as a company is going to be acquiring assets, then the new assets can be put into that company or into that trust. Assets can be removed from that trust. Expenses can be paid for, for whatever living expenses. Even, it's not. There are very few restrictions on how the money can be used. And much like a business entity, the trust is somewhat in the background. Typically does not interfere with routine activities, but it provides a structure for how to manage and control assets as a company, that concept. Talking a little bit more about who is involved. So I indicated using the company or analogy. The owner of the company would be considered the trustor, the person who puts assets into the company. There are other terms that are used, basically referring to the exact same position, same authority, same control, so forth. So in addition to trustor, sometimes the owners are referred to as the settlor, the idea being that because this is a trust, they're the person who is settling or placing assets into the trust. Somewhat of an archaic term, so I don't like to use that. I don't think it's nearly as descriptive. Other than trustor, good descriptive terms are grantor, because the owner is granting assets to the trust, or creator, because the owner is creating a trust, typically just for their benefit. Then the other person involved is the trustee, who is essentially a manager of the assets. In the company analogy, or the trustor would be like the shareholder who puts assets into the corporation, and the trustee would be the president who, or other employees who manage the assets for the benefit of the owner. And in part, it's the trustee role that can change easily from one person to another. If the trustor or trustors, if it's husband and wife, put their assets into a trust and they're currently the trustees because they're managing the trust assets, they can designate somebody to take over the management of the trust for them. That could be somebody who is a professional manager. It could be a family member. Sometimes managers, banks or trust companies are selected to act as the manager of the assets. So it's the trustee position more than any other that's likely to change. The other people involved in a trust are the current beneficiaries and the future or contingent beneficiaries. In a husband and wife trust, the current beneficiaries are the husband and wife. Everything is used for their benefit. There are contingent beneficiaries, which may be children or charities, nieces, nephews, brothers, sisters, other family members, may be considered beneficiaries after the owners, after the trustors have passed away. But typically, contingent or future beneficiaries don't have any rights unless and until they are designated as beneficiaries to the trust when the trustor or trustors have passed away. Other people often involved in trusts, really from a management or advisory perspective, are the attorneys, financial planners, accountants, anybody, the trustors, or trustees, if the trustees are different from the trustors. Anybody that they need to consult with or desire to consult with can be used as advisors. Those are, of course, paid advisors. You could have unpaid advisors of, friends or family members, but if they're unpaid advisors, hopefully they are well qualified in what they're doing so that there won't be any improper advice being given. So like I said, there are many different types of trusts, different uses and functions. Our focus is going to be on family trusts, and I used the term revocable before, and sometimes these words can be confusing because revocable and irrevocable are very similar, but a revocable trust is one that can be amended, modified, changed, whereas an irrevocable trust, and we'll talk about a couple of those, an irrevocable trust can typically not be changed. But during the owner's lifetime, the trusts we're talking about are revocable, amendable, changeable. They become irrevocable and can no longer be changed after the owners, the trustors, have passed away. So they're referred to as revocable trusts, but they at some point do become irrevocable. And so when somebody passes away, they don't need to be concerned about the fact that a manager might, a trustee, successor trustee, or a child or something might try to come in and change the document. Once the trustors are deceased, then the trust document can no longer be changed unless the court approval was sought, and that would be pretty rare. We also use the term living, and we refer to these as living trusts because they're in effect during somebody's lifetime, and that's really to distinguish them from testamentary trusts, which would go into effect only through a will. It was not uncommon before revocable living trusts became popular that testamentary trusts were set up through somebody's will, and in the process of probate, the court would then set up or at least authorize the establishment of a trust for further management of assets. But those testamentary trusts are very rare now because it makes no sense to go through probate to set up a trust when you can just set up the trust without going through probate. And as I described, inter vivos just means during life or during lifetime. These trusts we're talking about, family trusts, can be revoked, but they also have post-death benefits. So some of the advantages of trusts, the trustors manage the assets during their lifetime. They have complete control of the assets. If the trustors were to decide, or let's say there were husband and wife as trustors, one spouse is deceased and the remaining spouse has some health problems and decides they really don't want to control the trust assets at that point, they can turn over the control to a successor trustee. But until such time as they either die, make a decision to transfer control, or if they lack capacity due to an injury or illness, Alzheimer's, whatever, in those types of situations, the responsibility can be transferred over to the successor to the first trustees. But until that time, then whoever sets up the trust has complete control over the trust assets. And they also select the successor trustees. So in a sense, they still have control. Their wishes are still being carried out. It's just they could give up the actual right to control the trust assets. And if it's just maybe a temporary disability, Let's say they were involved in a serious accident and they needed to turn control over to a successor trustee. Once they recover from a serious injury, or let's say they were even in a coma for some period of time, if they recover, then they can be restored to the trustee's role once they've recovered. One of the biggest advantages of trusts is the cost savings element, the elimination of a lot of the redundant probate costs. There is almost always some administration for trust assets. There still needs to be a process to get assets transferred. If there's real property that needs to be sold to transfer to the beneficiaries, then there's going to be sale costs associated with that. But the costs of administration are usually much lower in a trust administration, and they're usually whatever the work is that's being done by accountants or attorneys that would typically charge on an hourly basis. The work that's being done on an hourly basis is usually much less than the percentage of the assets that would be going towards administrator fees and attorney's fees that are set by statute in a probate. Because there is reduced costs and reduced procedures in a trust administration, the beneficiaries or heirs can usually have the assets distributed to them much more quickly. Another advantage of trusts is it's not as much of an issue now as it has been in the past, but trusts have often been used to reduce or eliminate estate taxes, and this is usually done, if anybody's familiar with trusts, done by using what are called AB trusts as subtrusts in order to minimize or eliminate estate taxes. But the estate tax exemption amount is over $11 million per person right now, and has been since the tax law that was enacted in December of 2017, one of the Trump administration early tax provisions. So the need for using AB trusts for estate tax purposes is not usually an issue right now for a lot of people, but that still exists as an option. And if Congress were to reduce the estate tax exemption amount, then estate taxes are going to be applicable to a lot more people than they have been for the last few years. Another key aspect for the benefits of having trusts is the trustor, the trust owner, selects who will be the beneficiaries and who receives what assets, and the trustor can also specify when those assets would be distributed, whether by time or often by age. The trustor can make a restriction to only distribute assets when a beneficiary can establish that they are free of alcohol abuse or drug abuse. So those types of provisions can be written into a trust. Also, we can write into a trust provisions to protect assets from going to creditors. A lot of times the last thing a person would want who's been spending their lifetime gathering and accumulating assets is for assets to go to a beneficiary and then have the beneficiary immediately have to turn around and give those assets to the beneficiary's creditors, so that there can be protection established there. A number of times, particularly if there's been a second marriage, there may be a desire to establish a life estate in a home or other real property for the benefit of the second spouse. Types of provisions can be put into play fairly easily. The trustor can set aside money for education, or if the trustor has an age limitation for when assets would be distributed, but they want to be able to provide money so that their child or grandchild, let's say, can purchase a home, then that could be made as an exception to the age limitation. And the age limitations can really be anything that the trustors desire. By California law, through a probate, all the assets would go to any child, minor, as soon as they turn age 18. Many people don't want assets to be going to 18-year-olds because they're not usually very effective in managing property. So they want to place age restrictions. And so frequently it's age 21, 25, or even a combination of a certain amount of assets distributed age 21, 25, and 30, a third each maybe, something like that. Those are often provisions that are included. So there's a lot of flexibility as far as how the trustor gets to decide when and where and what assets get specifically distributed to which beneficiaries. Along with these other benefits, a lot of people realize that sometimes when mom and dad pass away, the kids don't get along. That can result in contests to wills, and trusts also can be contested, but it's much less likely that a trust is going to be contested because the trust document itself is more involved than a will, more complicated than a will, contains more provisions than a will does. So there's a lot, you can easily demonstrate that a lot more effort goes into establishing a trust typically than establishing a will. And you can make some very clear provisions in a trust to discourage people from making a contest to the trust. It doesn't always stop people from making contests, whether it be probate or trust. They can still enter, if they're of a mind to. It doesn't take a whole lot to file a complaint with the court to try to get the trustor's instructions overturned or changed. Another key aspect for trusts is for people who have a family-owned business, putting the assets into the trust, whether it's a corporation shares or if it's a sole proprietorship or a membership interest in a limited liability company. By putting a business entity into a trust, it makes it much easier to assure that that business can continue to be operated with basically clearly taking into account the fact that it's usually the business owner who's passed away, but it's much easier to pick up the pieces and for other people to be put into place to operate the business if its ownership is in a trust than if it was not in a trust, where there would have to be specific approval sought from the probate court in order to continue the operation of the business. And technically, until that approval from the probate court was obtained, there would not be a right to continue the operation of the business. So some other benefits of trusts: forced sale of assets is unlikely, as contrasted with the probate. This helps to preserve assets and asset values. The trust can allow for annual gifting. In other words, if a trustor has been making annual gifts, either for children or grandchildren or charitable gifts, that gifting can continue. The trustee, if they're authorized, can continue with those gifts. A specific type of revocable living trust is a qualified domestic trust, which allows for the extension of tax benefits to a non-citizen spouse. These aren't as common with the increase in the estate tax exemption amount, but still available and something that needs to be considered if there's a non-citizen spouse. Of course, one of the typical benefits of trusts is not having court or government involvement, unlike probate, which everything is pretty much directed by the probate code. California Law Probate Code and court supervision. But even though there's no court involvement directly in trust administration, if there is a problem, then the matter can be brought before the court if there's some type of a dispute that needs to be resolved, or if the trustee needs instructions for some reason, then the courts are available to address those issues on an as-needed basis. Another advantage is the trustor gets to select who they want as trustee. So it can be a family member. Frequently, if the assets are going to be going to children, then more often than not, children are designated as successor trustees. If there are no direct family members, there may be a family friend. In the last few years, the use of professional fiduciaries has increased. There is now essentially not technically a licensing mechanism, but for practical purposes, people can qualify as professional fiduciaries and be listed as such on a state of California website. People who've met certain criteria and usually are well experienced in handling trust administrations. You could also select an institutional trustee, whether it be a bank, a trust company. Most of the banks, big banks, have their own trust companies. Many financial advisory firms have their own trustee departments, help manage assets. So there's a great deal of flexibility as far as who can be selected as a successor trustee. Another key benefit of trust that we'll get into a little bit, hopefully get into a little bit later, is helping to avoid a court conservatorship. If a person becomes incapacitated, whether by injury or illness, the trust can be used to step in and have the successor trustee carry out the instructions of the trust while the trustor is incapacitated during their lifetime, which and court conservatorships are usually handled through in California, they're handled through the probate departments of the Superior Court. And court conservatorships can be very expensive. There's, again, a lot of due process requirements similar to probate, and accountings, regular accountings to the court. So it can be a much more cumbersome process than having a successor trustee step in and handle things for the incapacitated trustor. And there's typically no public disclosure. If somebody does decide to file a lawsuit relating to the administration of the trust, there is some public disclosure there. So that that might be an issue or concern, but usually that's not my experience has been that those are just a small percentage of the of trusts that need to be administered have those types of issues. There are some disadvantages with trusts. I've had, in terms of this first item here, I've had at least one client, probably more than one, who has no children, and he basically he thinks his wife will outlive him, and he basically is taking the approach that he's not going to do any planning because he's not going to be here to handle those assets. He'll be deceased, and he doesn't want to incur the cost of doing the trust. In the question a minute ago, I gave you kind of a rough starting point regarding the cost of establishing a trust and other estate plan documents. If you don't do any planning, you don't have that cost. So, but somebody's going to pay, the expense for administration, even if you don't pay the initial fee for establishing the estate plan in the first place. There are tax filings, not can be, there are tax filings when a trust becomes partially or totally irrevocable and the trust has income. In basically tying in with the question that was asked a minute ago about how long a trust should be in place, one thing that discourages trusts from being in place for a long period of time is the fact that trusts are taxable if they have income after they have become irrevocable and can no longer be changed. Usually an individual such as a beneficiary, a person, they have more tax deductions available to them for assets than do trusts. So the effective tax rate on trusts is higher than for individuals. So that's an incentive to distribute assets sooner rather than later. There are some expenses that will need to be paid in terms of administration. Like I said, if there are assets, those assets still need to be distributed. So if there's real property, it can either be transferred as is through a deed, or if the real property needs to be sold, then the trustee is responsible for selling those assets. And if the trustee is an institutional trustee or professional fiduciary, the probability is that they'll charge more than I'd say what we call a personal trustee, typically a daughter, son, brother, cousin, somebody like that who's handling the administration. So that the trustee fee could be higher using an institution, trust company, or a professional fiduciary. But if the assets are sufficient that those professionals are hired, then it may make sense to have that administration done, by somebody who's receiving a fee, a fairly, significant fee for the that's being handled. And another disadvantage is the failure to properly fund the trust. And so we're going to get into right now issues relating to trust funding. Just kind of as a summary, though, on trusts, in my opinion, advantages of trusts almost always outweigh the disadvantages. And as I indicated before, a revocable living trust usually is basically the foundation of a complete estate plan for somebody who owns real property or has cash or other liquid assets for $150,000 or more. So on trust funding, a trust without assets is of no value. If somebody goes to the expense of putting a trust together but does not put assets into that trust or does not keep assets in that trust, they have wasted their money. And so when a trust is established, usually this is the first time that the funding is done. And just kind of as an aside, sometimes people will ask me, well, can't I just go to LegalZoom or one of those companies that's online and have them prepare a trust for me? Certainly it's less expensive than having an attorney prepare a trust. But one of the problems I've seen with people going to an online service or even going to sometimes a paralegal or an attorney who doesn't handle estate planning on a regular basis is that the trusts are not properly funded. And just some of the quick procedures that have to be used for transferring real property is I would prepare a deed. changes the title from the name of the individuals and transfer it to the name of that individual as trustee of their trust. We record that deed, and then that deed or that property is then funded in the trust. Corporate stock can be changed by either reissuing stock, and so that there's a new stock certificate, or preparing a written assignment of the stock ownership. Bank accounts and other investment accounts at financial institutions. It's just a matter of changing title. Again, typically it would be, let's say, John and Sue Smith have title to their investment account at Schwab Investments, and they establish a trust. So they advise Schwab Investments they want to change title to Bob and Sue as trustees of the Bob and Sue Trust. And once the title is changed with the financial institution, then that asset is funded into the trust. Same thing with individual investment accounts, annuities, other assets like that. Just change the title with the institution, and then once the title is changed to the ownership of the trustees, in the name of the trustees of their trust, then that title, that asset is then part of the trust. Same thing with partnership interest, limited liability companies, real estate investment trusts, tenant in common assets. It's just a matter of changing title or doing an assignment of those assets to the trust. And so typically when a client comes to me, I make sure that they have the information that they need, and they know what accounts, what institutions need to be contacted to change title, or if it's I prepare an assignment, or I do the prepare and record the deed that needs to be issued in order to change title. So as I said before, we were going to get to the role of the pour over will. Usually a will is prepared when a trust is prepared. And the purpose of the will in this instance is not to distribute assets, which historically has been what's used to designate beneficiaries. That's all covered in the trust. The purpose of the will that comes alongside of a trust pours over assets that are outside of the trust into the trust. So for example, if there is personal property that has not been assigned to the trust, then the will basically specifies that that personal property gets poured over and handled through the trust for administration purposes. If there's titled property that is not in the trust, for example, I've seen situations where real property was home, for example, the title was transferred into the trust. When the trust was established, at some point the owner took title out of the trust. Frequently it would be if a lender wanted title taken out for making a loan, and they forgot to put it back into the trust. So in that instance, the will would be needed in order to make sure that the assets is going into the trust. Well, when we consider trust funding, we also have to take into consideration what assets are not transferred to a trust, because not everything goes into the trust. Life insurance typically is not owned by the trust. Usually life insurance is owned by an individual, and it doesn't need to be owned by the trust because there is a contract, a life insurance contract, between the owner and the life insurance company that indicates that the insurance company is going to pay out to the designated beneficiaries when the owner passes away. Because of the designated beneficiaries, there's no reason for the trust to be the owner of the life insurance policy. So those assets would typically just be transferred separate and apart from the trust. You could have situations where you might want to make the trust a beneficiary or a contingent beneficiary. For example, for a family with young children, they may want to, let's assume for the sake of discussion that it's a life insurance policy on mom, and the primary beneficiary would be dad, but you've got minor children, so you don't want the possibility of the life insurance proceeds sitting in an account and them receiving the money when they turn 18. So you make the trust a contingent beneficiary. So if dad is deceased, mom's life insurance policy would be paid to the trustee of the trust. That money could then be managed and invested for the benefit of the children, and then distributed to the children when they got to the age that that mom and dad designated that they would receive benefits under the trust. And the trustee can use the money for their benefit to provide for the needs of the kids until they get to the age where they can receive the assets themselves. Any tax qualified plan does not get transferred to a trust, whether it's an IRA, an individual retirement account, a corporate 401k plan, a teacher 403b or TSA plan. These and other types of tax qualified plans also don't need to be transferred to a trust, and there would be some tax disadvantages from transferring ownership to the trust. They don't need to be transferred to the trust because, again, there's a contract between the owner and the plan administrator with beneficiaries designated, and when the owner passes away, the assets remaining in the plan are going to be distributed to those beneficiaries. That is one reason why it's important to make sure that beneficiary designations are kept current, assure that these types of assets, even though they're not in a trust, not funded in a trust, are going to go where the owner wants them to go. Pension plans and automobiles also don't go into a trust. All right, so the next thing we want to get into then is responsibilities of successor trustees. As I've kind of indicated so far, the successor trustees can step up or be called upon to step in and act as trustee in two different situations. In the situation of an incapacitated trustor, where usually there's a medical opinion indicating that the trustor can no longer manage their financial affairs, and so the successor trustee steps in, or when the trustor is deceased, then the successor trustee steps in. If it's a husband and wife trust, then typically the surviving spouse will be the sole trustee, but if both spouse, which of course is the plural of spouse, if both spouse are deceased, then the trustee needs to step in. A lot of the responsibilities for succession due to incapacity or death are similar or the same, so we won't belabor repetition, but I did want to list each of the different categories of the responsibilities. So typically the first thing a successor trustee needs to do if there's an incapacitated trustor is to review the trust, seek any professional advice as needed. Usually that would be with an attorney or a financial advisor. The person stepping up as successor trustee should accept that responsibility in writing. Even if they're the only designated trustee, they still need to demonstrate to banks, financial institutions, and any interested third party that they are in fact the trustee. And so that should be done in writing. Once they become trustee, they need to make sure that the assets are being protected, that appropriate insurance is in place, um, any financial accounts are being controlled, whatever would be required to make sure, just like you would protect your own assets, the successor trustee needs to make sure that the assets coming under his control are protected. Banks and other institutions would need to be notified if there are account titles that need to be changed. The trustee, in order to be able to, for example, write checks off of a bank account or investment account, needs to notify the bank or investment institution that they're now the trustee. So the title on those accounts will be changed so that the trustee can then write checks from that bank or other institution. If there's are any disability benefits available or other benefits, then the trustee should apply for those benefits. They should make sure that they're handling all the trustor's bills and any other things that need to be paid. And some of these responsibilities might be done under a power of attorney, and some of these responsibilities might be done under the trust itself, depending on exactly how the assets were titled. So, for example, it's common an individual's regular checking account may not necessarily be transferred into a trust, and so the successor trustee may actually be acting under a power of attorney to manage a non-trust asset, as well as handling trust assets as trustee. The trustee wants to make sure that they maintain separate accounts and do not commingle any trust assets with their personal funds. Could be liability on the part of the trustee just from commingling personal assets with trust assets, even if there's no technical harm. So it's important that that process be maintained, and that the trustee needs to make sure that they're keeping accurate records. They may need to file tax returns and do other things. So making sure that accurate records are maintained is appropriate. If the trustee needs help from a bookkeeper to handle some of these instructions, or a financial advisor, then they have a right to seek advice at the expense of the trust to make sure that they're doing their job correctly and to make sure that all the assets are properly protected. After the death of the trustor, a very similar opening process, reviewing the trust, seeking professional advice as needed. Again, accepting responsibility in writing, making sure that the trust assets are protected. Another new thing that will need to be done during the time the trust has been in existence, even if the trustor is incapacitated, the trust is at that time using a person's Social Security number. So any accounts that are opened in the name of the trust will be opened using the Social Security number for husband and or wife, or just the individual if there's no husband or wife. But when the successor trustee steps in and the trustor is deceased, the successor trustee needs to obtain a tax identification number, also called an employer identification number, so that they can change titles to the bank and make sure that they were doing proper tax reporting. They also need to, once they've got the tax ID number, they need to notify the bank, change titles, that type of thing, so that they then are clearly in control of the trust assets, for making sure that those trust assets are protected and used as designated in the trust. If there are any death benefits available, the trustee usually is the one who applies for those benefits. They should inventory trust assets, have basically a list of trust assets to make sure that they have identified everything and determine values for those assets, whether it be by appraisal, maybe getting, if it's real property, maybe getting a real estate broker's opinion of value. If there are other assets, they may need to be appraised. It just depends on the assets. Then the trustor also needs to make sure that all the trustor's bills are paid, all the administration expenses are paid. If assets need to be sold for distribution to beneficiaries, then those assets need to be sold. Basically, any financial related transaction is typically done by the successor trustee. Although not technically part of the trustee's responsibilities, it usually falls to the successor trustee to at least make the contact with and obtain claim information, claim documents from life insurance companies and retirement plan administrators. Usually it's easier to have that being done by the trustee than having, let's say, other family members handle that responsibility. The trustee is basically just kind of a one-stop shop for anything relating to the financial assets of the deceased person. Under California law, there is a requirement that the trustee provide notice that the trust is now irrevocable because of the death of the trustor, and that notice needs to go to beneficiaries of the trust and to any other legal heirs if there are heirs of the individual who are not also beneficiaries. And then during the administration process, the trustee needs to keep beneficiaries reasonably informed. So after the death of the trustor, again, no commingling of assets. Again, keep accurate records and do an accounting for beneficiaries. Sometimes the beneficiaries, if the family gets along well, the beneficiaries may want to waive an accounting. That certainly cuts down on the administration expense. So, there may be an option for waiving accounting, but unless that's done in writing, an accounting is required under California law. It hasn't always been required, but as trusts have become more and more popular, the state of California in particular has put more protection mechanisms in place, more procedural due process items designed to protect heirs and beneficiaries. And that notification I was just talking about is designed to protect legal heirs because there have been situations where somebody becomes a close friend of an elderly person, gets them to put them in as a trust beneficiary and exclude the heirs, and the heirs may not find out in time in order to do something to make sure that their interests are protected and that the friend of the deceased is held accountable. Again, assets are sold as necessary. Prepare any necessary income tax returns if there's sufficient income to require a tax return. Distribute the assets to the beneficiaries is basically pretty much the last step in the trust administration process. Just kind of as an aside, in that process of distributing assets, if you were ever called upon to be a successor trustee, it's important that you get all the beneficiaries to sign a release of all claims before the money gets distributed, so that somebody doesn't come back and make some type of a claim against the successor trustee after the fact when there's no money available to provide any type of a defense for the claims of beneficiaries. Okay, so there are other types of trusts that are commonly used. I've mentioned the second one, special needs trusts. Irrevocable life insurance trusts are still used, but not as often. And separate property trusts are used where there's, let's say, inheritance money, inheritance assets, and the beneficiary wants to set that up in a separate trust. Those are typically still revocable living trusts, but they're for separate property assets. A qualified personal residence trust can be a great way to make a tax beneficial gift of a home, again, for high net worth people. Minors trusts, charitable trusts, and some other tax related trusts are available. Sometimes there are irrevocable trusts, but the problem with these is that the trust assets are no longer controlled by the grantor, the trustor of the trust. They have to be controlled by a third-party trustee. And getting trusts changed, irrevocable trusts changed, even if there's a change of circumstances, it's difficult. Okay, so there are some things that can be used to avoid probate, and we've really already touched on some, but so we'll go through this relatively quickly. Item B there, joint tenancy. I'd say the most common way that people, husband and wife, hold title to real property is in joint tenancy. It seems to be the default for escrow companies. And if they don't receive any other type of instruction, then that's what they're going to do typically when they prepare a deed for new property that's acquired. That's all well and good. The property goes to the surviving joint tenant when one of them passes away, but that doesn't create an overall plan for what happens with that property when the second owner passes away. And it doesn't have to be husband and wife. Sometimes family members own title in joint tenancy, but it's only a stopgap measure. There's still some ultimate planning that will need to be done after one of the joint or after the joint tenants pass away. Community property with right of survivorship is a good alternative to joint tenancy, but again, doesn't cover what happens ultimately when the second spouse dies. California, a few years ago, developed and established a transfer on death deed. These are much more complicated in California than they are in other states, and in my opinion, are not a good alternative, but that's a much longer discussion. We've talked about the fact that employee benefit plans, including 401ks, pensions, IRAs, those types of things have beneficiaries designated, so they're not part of a trust planning, but also avoid probate. Life insurance with proper beneficiaries designated. Private annuities and commercial annuities can have beneficiaries designated. Frequently, people will establish accounts with a transfer on death or payable on death beneficiary designated. Those accounts then will go to the designated beneficiary so long as they're still alive. So those would not go through probate so long as the beneficiary listed is alive. Powers of appointment is more complicated than we can get into now. Lifetime giving, of course, provides a mechanism. Irrevocable trusts are an option. With savings bonds, you can also designate a beneficiary, and those bonds would then go to the named beneficiary. You could do the same thing on a stock brokerage account or a Totten trust, which is, again, more detail than we can get into right now. You can set up Uniform Gift to Minors Act accounts. You can also set up a 529 plan or education IRA, which I should have put on the list, but those are a good way to transfer money to, let's say, often grandchildren so that they can use the money for education purposes. You can do different types of charitable transfers, whether it be an outright gift or some type of a gift annuity. Other options are charitable remainder trusts. A lot of times when people set up trusts, the default is to provide the beneficiaries or designate the beneficiaries as only children. But good works don't happen by accident. And the only way really to make sure that assets are used for good works to charities, whether it be colleges, churches, you name the charitable beneficiary. There's lots of good works being done out there in the world that want to encourage gifting through estate plans. Charitable lead trusts are another, just an alternative way of gifting. Okay, so let's talk a moment about protecting assets from creditors. Certain assets, well, first of all, the main thing really to note here, a lot of people think that by establishing a trust, that creates protection from creditors' claims. In most instances, and I'm kind of at point C before getting to A and B, but in most instances, revocable living trusts themselves do not provide any type of creditor protection or asset protection. Some irrevocable trusts do, but most revocable family trusts do not. But there are other things that are frequently done in conjunction with trusts as part of an estate plan that may provide and should provide protection from creditors. Just from a basic law standpoint, certain assets, point A, certain assets are already exempt from claims of creditors. And when I say claims of creditors, it really has to be in the form of a judgment. Just a creditor claim is not sufficient for them to attach assets. They have to have some type of a lien. Usually that's a judgment lien on assets. So employment benefits are tax exempt. Tax qualified retirement plans are tax exempt. Life insurance is tax and creditor exempt. So these, and I said tax exempt, but these are exempt from claims and judgments of creditors. The use of business entities, whether it be corporations or limited liability companies, used to be that limited partnerships were often used, and pretty much those have been replaced by limited liability companies because LLCs are more flexible. But these business entities can be used to manage and protect assets and can be owned by the trustor through the trust, so they would still get the benefits of the trust, but their assets are technically in a business entity that's going to be protected from creditor claims. Another key aspect of planning, not only to avoid probate, but also to avoid conservatorship. I mentioned this briefly before when we talked about advanced healthcare directives, but a conservatorship is a court-appointed, court-supervised process. A court order is required in order to establish a conservatorship. And when a conservatorship is established, it can be one of two types. Can be a conservatorship of the person, where the conservator, the person responsible for the conservatee, that conservator handles living arrangements, medical care, any personal aspects that's needed for the benefit of the conservatee. The other type of conservatorship is of an estate, conservatorship of the estate, where the property and assets that are owned by the conservatee are managed by the court-appointed conservator. And the conservator often is a family member, but not necessarily. It's certainly somebody who's going to be approved by the court. There's also a bonding requirement like probate in order to provide protection in the event that the conservator walks off with assets, that type of thing. A conservatorship of the person can usually be avoided with an advanced healthcare directive because there's somebody designated by the person to act as on their behalf. And the advanced healthcare directive also specifies who that person would want to act as a conservator if a conservatorship was actually necessary. But with the advanced healthcare directive, usually a conservatorship can be avoided. A conservatorship of the estate can often be avoided with both a power of attorney and a living trust working in combination. So those, that kind of brings full circle why these other documents, the advanced healthcare directive and power of attorney along with the living trust, provide good alternatives to keeping issues out of probate and out of the control of the courts.
Okay, well, thank you very much, Jay.
Certainly, glad to be able to help out.